Good morning, everyone. Good morning. My name is Stephanie Kelly. I am a partner with Ice Miller. We have offices out not too far from here in Lisle, as well as downtown Chicago, in Illinois, and then we're also in Ohio, Indiana, New York, and some other places. First of all, please accept my apologies. I naively thought that leaving 2 hours ahead of the time would be sufficient to get to Oak Brook on time, and apparently I was wrong. So my apologies. I've never done this. I feel quite horrible about it. I'd like to just talk to you today about some things for you all to think about into the new year. Some of these might be refreshers or reminders. Some of them hopefully will be something that'll help you kind of, click something in the back of your head. Oh yeah, I've been meaning to deal with that. I know a lot of you are in HR or legal, and you deal with these issues on a regular basis. So, like I said, I'm a partner at Ice Miller. I am a management side labor and employment attorney. That's all I do. It's pretty much all I've ever done. I litigate, and I also do counseling. So I litigate all manner and method of claims brought by employees against their employers. Title VII, ADA, ADEA, FMLA, FLSA, whistleblower retaliation. I do things like drafting restrictive covenant agreements or enforcing them in court if necessary, drafting employment agreements. I do a lot of the fun policy work, helping folks like you draft handbooks and social media policies and sexual harassment policies and all those things that our employees read from cover to cover the first day that they start working, and then sign their lives away when they sign the acknowledgement. I do that as well. One of the things that I enjoy doing the most, though, is training. A lot of, specifically management training when I get that chance, because I think it's the opportunity to get in front of the folks who are making the decisions in real time and give them some pause or give them some tools to work with their employees. So that's something I do as well, on performance management, on how not to discriminate or harass your employees, on wage and hour issues, things along those lines. And it's good work, and I enjoy that as well. It makes it to be a fun practice. Today, I want to just let you know I'm going to respect your time. I know you guys have places to go and things to do, so we're going to get out on time. And Kimberly, if you can just kind of wave and let me know how we're doing on time. I'll make sure to hit the highlights and if we're not finished yet. Okay, so 3 things that we're going to talk about today. First are the Department of Labor's proposed white-collar exemption regulations. I'm sure you've been hearing about this for a bit. We'll talk a little bit about that. And then we'll talk about leaves and accommodations. This is something that anytime I get in front of a group of folks, I always feel this is a great topic just because it is something that I get calls on weekly from clients about how to navigate FMLA, how to navigate disability leave, how to manage it. And so I always think it's a good topic, and hopefully it will be for you guys. And then lastly, we'll talk about some recent updates regarding independent contractor law and employee status. So I feel like I have been Paul Revere for the last year. I've been going around, the regulations are coming, and they were supposed to be here by now, and they're not. But what we do know is that the Obama administration asked the Department of Labor, it's been now, I believe sometime back in 2014, to revise the white-collar exemptions. Now, the white-collar exemptions are those exemptions for the executive. So executive exemption, if you manage 2 or more full-time employees and your primary task is management. The administrative exemption, that's always the fun one. We throw a lot of folks into that, and sometimes it's right and sometimes it's wrong. But ultimately, the test being of whether or not that individual is using their independent judgment and discretion in the exercise of their duties. The computer exemption, and that's always a fun one because we want to just kind of throw everyone who touches a computer under that exemption. The truth of the matter is that person needs to be degreed, it needs to be some type of programming or coding, it can't just be a help desk type person. But that exemption, and then as well as the professional exemption. Folks like me would fall under that, lawyers or someone who has a professional degree. And then you also have the highly compensated test, which previously had been, I think, anyone earning $100,000 or more annually would be considered exempt from overtime. All of those under the radar to be changed. The idea being that the government really hasn't looked at these in quite some time, and maybe it's time to make some adjustments. So we did spend all this time speculating what's it going to be. Then we saw the proposed regulations, and this is what they were. So right now, currently, there is a minimum salary level that's required. If you are earning below that level, or excuse me, if you're earning above that level, then and you meet the other parts of the test for the executive or administrative or professional or computer exemption, you would be considered exempt from overtime, meaning that you are not obligated to pay that employee overtime for all hours worked over 40 in a work week. So that is currently $455 a week. The proposed regulations would raise that to $921 a week. That averages somewhere between $47,000 to $50,000 annually, meaning that you could have employees who are currently, you would consider them to be exempt. Now that level, they might be non-exempt because they will not be under that threshold level. Part of the reason is that index hasn't been raised since 2004, so you're accounting for inflation and whatnot. The proposal is that would be subject to annual adjustment, so we're not going to just go 11, 12 years, not have that minimum salary level raised and then do another huge raise. It would be probably raised every year according to inflation or the CP. There's a couple of methods that they're looking at. Employers would have a minimum of a 60-day notice from the Department of Labor. So when the Department of Labor decides, okay, we're going to raise that minimum salary level, they would have to provide a 60-day notice. Just a note, computer-related professionals can still be paid hourly under the new proposed regulations. So that's just an aside. And there is still some discussion as to whether or not non-discretionary bonuses would be included as a part of that salary. Right now, those are considered wages, and the speculation is that they will be, but that has not been affirmatively said by the Department of Labor. I mentioned this earlier. They would also propose to change highly compensated employees. So I had a client who, if you looked at these employees, they would all otherwise be considered non-exempt because they wouldn't fall under one of the white collar exemptions. But they were doing highly skilled work, highly valuable work, and were earning in the range of $80,000, $90,000, $100,000 a year. And so I think the thought process originally from the Department of Labor is, okay, if you're earning six figures, you really don't need overtime. But even that is going to go up to about $122,148. Also subject to annual adjustment. And the key there being that the employee would still have to earn that minimum $921 a week. So right now, there have been no suggested changes to the duties test. And the duties being, like, how do you figure out someone's exempt, right? I talked a little bit about the executive exemption. Well, we know that in order to be considered exempt under the executive exemption, you need to manage employees, 2 or more full-time employees. Your primary duty must be management. That means that at least the majority of the time you're spent doing things like hiring and training and disciplining and firing, if that's the case, employees, and not the assistant store manager who spends all of her day on the cash register. So arguably, and we've seen a whole slew of lawsuits about that, that person isn't actually managing, they're doing non-exempt duties. There is speculation that the Department of Labor may be moving to the California test, and if any of you all have employees in California, you know that's a different country as far as the law is concerned, but that the primary duty must be 51% or more in order to qualify under the exemption. So there's speculation. That did not come out this past summer when the proposed regulations were announced. However, there is speculation that it could still happen. All of these are still, exemptions are still going to hold water. The outside sales exemption, retail and service, motor carrier, and just threw this one in for fun. Yes, there is a sugar beet processor exemption. I don't know the origins of it, but there is one. I don't know if that applies to anyone in the room. So, there were over 200,000 comments received this summer. As I just said, the duties tests are still up for grabs. We anticipate that we'll hear sometime between June of this year and the fall, November, what the final regs will be. And then as far as when they will be implemented, but that is still unknown. What does this mean for you? The Department of Labor estimates that 4.6 million employees might be impacted by these changes, that they could be converted from non-exempt to exempt status, resulting in employers being required to pay these employees time and a half for all hours worked over 40 in a work week, regardless of whether or not they're currently salaried employees. That's a lot of employees. And I think, if we're being honest and we look at our employee groups, there are a lot of people in that range, right? The previous salary base was, I think, the equivalent of $23,500 a year annualized out to now $47,000, $50,000 a year. That's a lot of people. How do you staff? How do you schedule? Your employees currently scheduled to work 40 hours a week, or are they working 35 or 37 and a half? How are you going to handle overtime moving forward? How is that going to affect your payroll and your budgeting? These are kind of the things that start thinking about now if you haven't already. Because the impact is people that you previously didn't have to pay overtime to, you may have to now. We're thinking that common job classifications that are going to be impacted the most are those entry-level job classifications and some mid-level administrative employees and professionals. Industries that are going to probably see the biggest hits: office and professional workers, retail, food service, hospitality, any type of service industry. They'll probably see the biggest impact once these actually do change. So, what do you do now? When we started talking about this a little bit, the first thing is evaluate your positions to determine who's in that range. Is it really going to hit you or not? Or do you have a lot of employees in that range? It's also important, and I think this is something that can't be said enough, that salary, when you say that you have a salaried employee, that doesn't necessarily mean that they're exempt from overtime. We use these words interchangeably, but they don't always mean what we think they mean. Employers often say someone is salaried because they pay them the same thing every 2 weeks. However, they could be salaried. You could be paying that individual the same thing every 2 weeks, but they also could be considered not exempt and eligible for overtime if those duties tests aren't met. And feel free, if anybody has a question or a comment or wants to throw something into the conversation, please don't hesitate. So, some options if these regulations are going to kind of impact your workforce. First, you can raise the salary over the minimum for employees who are close. So if you've got an employee who's right on the cusp, maybe making about $45,000, and you evaluate, and they've been working routinely somewhere like 45, 50 hours a week, maybe instead of risking that overtime cost, it makes more sense to raise their salary so that they're not overtime eligible. So that's some risk analysis and looking at the cost and how that weighs out. Yes, sir.
On those thresholds that you had before, are those calculated based on 40-hour work weeks?
Yes.
So do not include any. So if their base is, say, 45,000, 40 hours, they may not qualify for the fact that they have to typically work 50 hours a week.
Correct.
They're still under the threshold.
Right. So the key for overtime is the law allows it. If you're not exempt, you have to pay time and a half for any hour worked over 40 that week. There are a couple ways to get around that. We'll talk a little bit about that, the fluctuating work week method of when sometimes you work more and sometimes you work less than 40 hours. But those numbers are based on an employee working what's considered to be full-time 40 hours per week. Oh, here we are. We are right here. That's the next point. You beat me to it. Consider changing to your fixed salary to fluctuating hours. So this is for folks that, you know, for instance, maybe you've got managers or some type of manager, like say we're working in a restaurant, so like a restaurant manager who sometimes works more than 40 hours a week, and sometimes if it's slow and you start, you know, letting people go, they're working less. You might want to consider changing your salary to fluctuating hours. When you do that, then the employee only earns half time for all hours worked over 40 in a week, as opposed to time and a half. Or, it's probably not my favorite, but it's an option, change your compensation structure to hourly compensation plus overtime. Would be another way to think about it. So there are always some potential trouble spots when we're looking at changes like this, significant changes like this. And the first one is scheduling off-the-clock work. And off-the-clock work would be work that is still considered work. Maybe the employee's working at home, they haven't clocked in, or they haven't recorded the time that they're working. Maybe they've been called on the phone on a weekend to handle a problem and they stayed on the phone for an hour. That all contributes to hours worked over 40 in a work week. We usually don't monitor, I mean, some of you may, but a lot of employers don't track the time of exempt employees. They don't have to punch in and out, they don't have to submit timesheets. So now you've got to start thinking about how are you going to capture that time. There are time recording obligations under the FLSA. So one, you've got to capture it to see how much time they're actually working, and two, then you've got to make sure that when they're working, they're being compensated for it. And if you've got someone that's been working, you know, in that 45, 50-hour range a week, you want to schedule their work so that they don't have to do that, or change or be willing to pay the overtime. Timekeeping is huge, though. So I often find that the difference between non-exempt and exempt, in some organizations, it's a huge cultural issue. I work hard, I'm willing to do whatever I need to do for the company, I shouldn't have to punch a clock, is the thought process. And I kind of get it, but then as a lawyer, I think, well, that's how you know you're going to get paid for everything that you do. So it could be a cultural thing for your organization. Well, now you're asking people who traditionally haven't had to keep their time and manage their time. Now I need you to fill out a timesheet every week. I need you to clock in on your computer when you come in. So that's, something to think about. And also, do you have methods or means to track and keep time? If you haven't had to do it before, how are you going to do it now? What if your people are out in the field? They don't start in one central place. They don't start their work at one central place in the middle of, at the day. How are you going to keep their time? So that's something to consider. And again, I talked about this, and it's going back to the gentleman's question. This is based on your regular rate. We're thinking it's going to include bonuses. We'll see what happens in the final regulations. The last point here is about smartphones and emails after hours. That's just something to think about. Does everybody need a smartphone? I think at first we gave them to our employees because we thought this is great. We're able to contact them at any time, and we'll be able to get the information that we need, and they can contact us. But now the truth of the matter is that employee is considered non-exempt, and they have that smartphone, and they already work 40 hours a week. Anything that they're doing, that checking emails, the responding to emails, taking phone calls for work, that's work, and they should be paid for it. So, something to consider or think about. Yes?
If you haven't provided the smartphone and somebody chose to check their work emails from home and answer, you're obligated to pay that time.
So, what I would say is you would first want to start with a policy that says we do not authorize off-the-clock work. We don't expect you to respond to emails after hours. So you start there. And then if they do, and it's something that's measurable, you have to pay them because it is work. But most employers have some type of policy that would say unauthorized overtime, you can't be disciplined for unauthorized overtime. But you have to start with the expectation of, which means that's a cultural shift, right? We don't expect you to answer those emails. Yes?
And presumably the rub being, they never pay me for overtime because they didn't reach this impasse where they do it and say they wouldn't pay me for it if they decide to file it.
That's what happens. So I've defended several class actions where that's the case, where phone calls and emails and text. And even though, wink, wink, they said don't do it, but they allowed it. They were the ones sending me the email in the first place. That doesn't mean you can't send it, but it also just means they need to understand that there's no obligation to respond until they're working. Or there's an email and they're saying, hey, this is important, we need this done, don't worry about it, we'll make sure we catch the overtime hours. And it's not, unless your policy is, and I would advise against it, that they would receive overtime for all hours worked over 8 in a day. You've got a whole week to make those hours work. So, if you did have to send someone an email to deal with an issue on a Wednesday night, I see you, that, maybe they get to leave early on Friday to balance it out. So, yes, sir.
Is there a target number for the number of employees for a company where they have to comply with this? Like, is it 25 and above, 10 and above, 3 and above?
Oh, it's everyone. It's everyone, I'm sorry. Everyone. Unfortunately. It's everyone. I think we've talked about this, yeah. So the comment period closed. We had a whole bunch of people commenting on it. So we've been told by the DOL that to expect the final rules to be published somewhere between June and November of this year. Within that time frame, they would also talk about when they would expect the rules to be implemented. My guess would be early 2017, which gives us all a year to kind of start thinking about and planning for and preparing for it. So anything else on the regs before we move on? Yes.
I got one little quick question. If by chance the Republicans wind up in the White House, is there any chance this goes away?
My guess is no, because the regs are going to be released this year. They'll go into effect next year. And because the majority of the reg is just adjusting that salary basis for inflation, it's probably not so much of a political issue. So my guess is probably not.
Thank you.
No problem. Anything else before we move on? All right.
I got one question.
Yes, sir.
We essentially have a classification for our shop floor supervisors that makes them hourly exempt.
Okay.
No, but there really is no such thing, right?
Right.
They'll make, let's say, $75,000 a year. They have management duties, they do all that. What we do is rather than paying them a salary, we pay them by the hour. We pay them for overtime, but they get paid straight time.
Mm-hmm.
Is this a problem?
It probably could be a problem now.
That, I guess the rub being they're basically salaried, which means we need to guarantee the payment even if for some reason they are not there doing the work.
So the first thing I would do is go and do an audit and say, let's see, can we find a way to make these guys really exempt? Because if they are really truly doing management duties, that would be my first argument.
Yeah, I don't think I have a problem qualifying them as
Yeah.
salaried. It's the fact that they only get paid for the hours they're.
Right. So that could be a huge problem if they're not exempt under any of the relevant white collar exemptions. If they're not, probably the executive exemption is the exemption we're looking at here because they would be managing individuals. But the failure to pay time and a half, that's the penalty. So, like I said, my first step would be to let's make these people look as exempt as possible. Yes, they manage. Yes, they make recommendations on who to fire. They hire and fire. They give performance reviews. They do counseling with their employees. I would list all of those duties out and build those up as much as possible.
I don't think I got a problem with that. I mean, I think I can just.
Then you're fine. Then they are exempt.
That really what I'm concerned about is that we don't pay them. We only pay them for hours they work.
Right.
Even though they're basically salaried people.
Right. So if they take off a week.
Other than if it's not vacation.
Right.
It's now it's on a daily basis rather than a weekly basis.
Mm-hmm.
So if you're not there, as I recall, that changed. But so if they're not there that day,
Mm-hmm.
they don't get paid.
Right.
That to me, so we're not doing that one component of salary.
Yeah, I'm not as concerned about that. We can talk a little bit later about it, but I'm not as concerned about, based on what you've just told me, I'm not as concerned. But I'd like to talk to you about it a little bit. And
All right, sorry.
no, it's okay. I just, it's not too much at all. It's a great question. A lot of employers do that. So I think it's a great example. As someone who's defended a lot of wage and hour class actions, I always get a little kind of wary when I hear someone say, but we pay them straight time. It doesn't mean that you can't, and we can talk about that. Leaves and accommodations, the bane of the HR person's existence, and management. It's hard, right? I always joke that one of the best gifts that Bill Clinton ever gave us was the FMLA. It's been 21 years now, and we're still trying to figure out how to implement this law. But you all know that medical situations can make it very challenging to manage your workforce. And there's a whole bunch of different laws that intersect to make it even more so complicated. So we have the Family Medical Leave Act, and we'll talk a little bit about that, and the Americans with Disabilities Act. But you also have things like whatever your individual work policies are, and if you have a unionized workforce, your collective bargaining agreement, if your short-term and long-term disability policies, workers' compensation, your anti-discrimination laws, Title VII and the like, state laws. All of these things combine to make it very challenging to manage a workforce when you have issues involving health, an individual's health, or the health of a loved one. So, we're going to start with the quiz. At the end of the section, I'm going to solicit an answer. We'll see who gets it right. I don't have a prize. Maybe an extra muffin. Okay, pop quiz. It's Monday afternoon, and Carla, who's pregnant, just called from the hospital to tell you that she wouldn't be at work today because job stress has caused pregnancy-related complications. She also told you that she might have to be absent at work for the rest of the week, possibly longer. Has anyone got a call like that before? So, what laws and policies are implicated by Carla's call? FMLA, medical or disability leave, leave under workers' comp, leave as a reasonable accommodation for a disability, leave as a reasonable accommodation for a pregnancy-related condition. I'm going to let you all just keep your answer in your head, and we'll come back to this at the end. Some of the objectives just for this section. We want to know that when you get a request for a leave of absence, beyond the FMLA, is there a legal issue under the ADA? I'm going to help you try to issue spot some of these things. Also, analyze facts to determine whether a possible ADA violation exists. So ADA being Americans with Disabilities Act. We also want you to be comfortable with options when FMLA expires. So I get those calls once a week. All right, this employee's been out, FMLA is about to expire. They weren't doing well before they left, and I really want to let them go. What can I do? I get those calls once a week too. So FMLA doesn't apply, or it doesn't apply. Employee hasn't been with us a year, hasn't worked 1,250 hours, or we don't have enough threshold number of employees, whatever it is, but we want to work with them, we want to give them some time to take off, but all of those types of issues. We'll talk about how to issue spot some of this. Just as a quick refresher, the FMLA provides unpaid job protected leave. Most employers will allow an employee to use their paid time off or vacation at the beginning of that leave period, but once that's gone, it's unpaid for employees who, and it gives you up to 12 work weeks off a year if the employee's worked 12 months or 1,250 hours. And the key being that that job protected leave is that the employee must be restored to the same or substantially similar position upon return from the leave. All right, so that's the FMLA. And depending on how you accrue your time, we see FMLA used mostly for things like maternity leave. That's probably your obvious thing that you see FMLA for, but there's also intermittent FMLA. Someone needs to be out for a week for a treatment or a surgery or something like that, or they have some type of condition that requires them to be out for half a day, once a week, or 2 days a month to visit their doctor or what have you. You see that a lot when you talk about FMLA. The Americans with Disability Act prohibits discrimination against individual because of the fact or perception that they have a disability. It requires an employer to provide a reasonable accommodation so that that person could do their job. But only if the individual can perform the essential duties or essential functions of their job with or without an accommodation. All right. It takes effect day one, so there's no 1 year, 1,250 hours threshold like there is for FMLA. Once that employee is yours, if something happens that triggers the ADA, that it takes effect their first day. Here is that, also the difference is accommodation is for the employee's disability only, whereas under the FMLA, an employee can take time off for their own serious medical or health condition or that of a spouse or close related family member. Whereas the ADA only protects the individual's disability. So the problem becomes that there are some scenarios that are related to leaves and absences that are rife for claims of discrimination. So for instance, you have an employee who says that they weren't considered or they were denied a promotion and because of absenteeism. But the only reason why they've been absent is because they have diabetes and they have difficulty managing that diabetes and it's required them to take time off or what have you. So therefore, the claim becomes that you're discriminating against that employee because of them having diabetes and not treating them like the other individuals who you did consider. That very well may or may not be the case, right? There may be other reasons why you didn't consider that employee. That employee may not have met the basic threshold qualifications for the job. But that can be a tension when the employee's condition starts to overlap with some of the considerations for the job, meaning you need someone who's got a good attendance record. That person needs to be there pretty much every day. And if I got an employee who routinely calls off, maybe I don't want that person to take this position, right? That's kind of usually the thought process we get. So you just want to make sure that when you're going through the analysis that you're looking at the requirements of the job, what's required, and if the employees can meet that with or without a reasonable accommodation. Is it necessary for that employee to be in the office every day? If so, why? And it can't just be because we all like to see each other every day. The law is really taking a long, extended look at how we work and kind of turning on its head traditional notions of reporting into the office every day because of the technology which allows people to work remotely and the reality that people do work remotely a lot. If you're letting someone else work remotely, maybe they have a temporary disability, they broke their leg. We know there's an end to it, but they can't come into the office and they're working from home. You want to consider whether or not someone with a disability should have that same treatment, because that's going to be the baseline that courts look at when they're trying to determine whether or not the employee's been discriminated against. Termination because of excess absences. This is a huge one, right? So sometimes an employee just takes off and doesn't tell you why. And it's not until you go to fire them that you find out, oh, well, the reason why I've had so many absences is because I've been struggling with this personal medical condition. The key here is to having a good policy that you follow, and that you follow it consistently with folks, meaning that and that means you apply it equally to your best and worst employee, right? Your best employee violates the policy, that's your go-to, your right hand, will come early, stay late. They have to receive the same discipline as your worst employee. If you don't do that, then what's going to happen is when you go back to defend yourself, the first thing the employee who got terminated is going to say, well, Bob was late 3 times and nothing happened to him. And you might say, well, Bob is different because he's a really great employee. Doesn't matter. You've got the policy. You've got to use it. You have to enforce it. Another place where we see it, a denial of a request for a leave of absence. So again, it's having a policy, sticking to it, being consistent with how you do these things. Always the place where you see any type of lawsuit is usually, I call them the big, it's about 5 or 6, but a termination, a demotion, a reduction in pay, a denial of a promotion. These are the areas where then people will say, oh, but it's not really because of my performance. And sometimes it is because of their performance, and sometimes it's a combination of things. But those are usually the kind of scenarios where you'll see this issue creep up. And then lastly, termination due to exhaustion of leave benefits. So I got this call 2 days ago. Employee was out on FMLA expired. Employee was on short-term expired. Employee is on long-term disability. We want to reorganize this job. We really want to we don't need this employee in this role anymore. We want to reassign to work and do something different. What can we do? Can you terminate an employee who doesn't come back to work? And I would say yes, after you've done some things and you've crossed your T's and dotted your I's and you're sure that you can. Yes, the law is not going to require you to keep somebody on the books who doesn't work. And not coming to work is not a reasonable accommodation under the law. But you do need to make sure that, I like to tell employees that sometimes. Well, my reasonable accommodation is that I just can't come to work. Well, I can't pay you. And it happens, right? But these are some of the tricky areas, and I'm sure some of you have navigated these before. So questions that you want to ask when these areas come up. Is the employee even eligible for time off of work? Have they been here long enough? Have they accrued vacation? Are they eligible under FMLA? Are they eligible under your leave policies, which may be more generous than the law? If the employee isn't eligible under any of those things, what do you do? What have you done before? Have you ever hired someone, didn't know they were pregnant, and then 4 months later, they said, oh yeah, by the way, I need to take some time off to have a baby. What did you do? They probably didn't have that much vacation. They weren't eligible for FMLA. So when you make those decisions, just think, if I'm willing to do this for this employee, am I going to be willing to do it for someone else? Because that's the trap that you kind of start to set. That doesn't mean you shouldn't let the person, have a couple weeks off. I'm not suggesting that, but I'm just saying, when you make those decisions, you're setting precedents for what you're going to do in the future. How much leave does the employee get, and in what form? Is this just paid time off? Is this sick leave? Is it really FMLA? What have you? Is the leave paid or unpaid? Most times it's going to be unpaid unless they have some PTO or vacation accrued that they can use. Yes?
I don't think I get to this, but
Oh, go ahead.
when do you think sick leave is going to come to Illinois? Not to shake your head to people.
So it's interesting. It hasn't been. It is picking up across the country. I've been working on helping a national restaurant chain implement a national paid sick leave policy. So it is kind of the thing that's happening. I will tell you that right now, I don't think it's on tap for Illinois. There are no murmurs talking about, there's, if everyone's tuned into what's going on in Springfield, it's, I think the big things Rounder's focusing on are workers' comp and, the right to work zones and whatnot. There's really no talk about it. Yeah. But that could change just because it is becoming, it's just kind of sweeping the country. And there are a lot of municipalities that are starting to pass laws on it. I'm getting ahead of state law. It's a great question. What happens to your employee benefits? All right, so an employee goes out on FMLA leave. They're not working. It's unpaid. How do you handle their benefits? Does the employee still have to pay? Are you paying?
Are you asking?
No, yeah, sure.
Well, they're still eligible for them, but if there's a premium that they pay, they're responsible for that and have to discuss that, but they stay on your coverage as a.
Right, absolutely. So a lot of employers forget about that. But yes, they should still be paying. What happens, do you have to hold the employee's job? How long do you have to hold it? Well, we know under the FMLA is job protected leave. You have to restore that employee to a similar or the equivalent job position on the expiration of their leave, being 12 work weeks. I will say though, that 12 weeks is not hard and fast. And there's a lot of cases out there that says, oh, if there's a week or two in between, that seem to stretch that 12 weeks. So I always want to urge employers, okay, you can't just say, okay, 12 weeks is up, that person's out. You want to look and engage because maybe now it's a disability issue. Maybe now the ADA is in play, which means that you have to start having a conversation with that employee about what they can and cannot do, and then make a decision of whether or not that works for your organization. So we always want to be careful about that. The same goes with, leaves under the ADA. They're not necessarily interminable. I mean, they should have an end. You should be in communication. You should know when you can expect that employee to come back. Because for an employer, you've got to backfill that position, or you've got to reassign work, or you've got to reallocate duties. So it's important for you to know how long you have to do that. So that requires you to have ongoing conversations with the employee, having them touch back with you, maybe getting, if they're out on FMLA leave, having them recertified. Having another certification done with their doctor and say, okay, does this employee really need to be off? Or do they need to be off every day? That's if you think you've got a malingering employee, or you've got someone who's kind of trying to game the system a little bit. Or you're just unclear. There are those, sad to say, FMLA mills, doctors who will sign anybody's FMLA form. Sometimes you get them back, you can't read it, you don't understand, it doesn't make sense. Ask questions. Because if you don't know, you're just going to get caught in this cycle of trying to figure out when this employee is going to get back and not knowing what the scope of the leave has to be. So it requires active communication on your part. Do we have to offer light duty? Okay, do you offer light duty to the folks who have like a temporary disability? They sprain their ankle so they can't stand at their spot on the line. But that's only temporary, it's gonna be for a week. What do they do for a week? Do they take the week off, or do you offer them light duty? If you have a light duty policy, then chances are you need to offer with the exception of the pregnancy law, and I think I have a slide on that. You do have to offer light duty to someone with a disability as well.
Is there ever any ties between workers' comp? We always push light duty, but as an employee illness, we usually don't accommodate that.
And that's fine.
Will there ever be any chance of that crossing?
That's fine. As long as if that's your practice, that's fine, because workers' comp, that is, you just don't want to, if your practice is outside of workers' comp, let's say it was someone's, accident that wasn't involving work, and if you're allowing that person light duty, then that's where the gray starts to happen. What if she comes back with restrictions? Restrictions! Restrictions are very challenging sometimes. This is someone who's required to lift, and the restriction comes back, they can't lift over 5 pounds. Well, they normally are lifting 20 to 25 pounds. What do? You're gonna take a hard look at the job. How long is that restriction? Is this a permanent restriction? If so, can the job be done? Is there a way to allocate the duties of the job, or so that someone else can do the lifting? If not, what else can this person do that would be similar but would not require lifting over 5 pounds? I think we talked about this a little bit. What happens if she runs out of FMLA leave? Then you have a tough choice to make. Obviously, it doesn't mean that employees get to stay out forever. But it really is going to depend on what the reason is. All right. So if they're caring for if it's for a family member, right? Their son has had to have some major surgery. They're taking time off to care for that person. All right. Well, at the end of FMLA leave, they have to come back to work, right? If they had open heart surgery and they're still recovering, there may be some room for leave as an accommodation under the ADA. So they're not hard and fast rules, they're case by case, which is the frustrating part about it. Yes, sir.
Well, I guess my understanding of FMLA leave, we had to take a pretty hard line on that, simply because even if it's the most heart-wrenching situation you could find, if you say, okay, that's all right, we'll extend it for a while, then every other employee has claimed it.
Yep.
And in your desire to be compassionate, you basically set yourself up for problems forever.
Absolutely.
Right or wrong with that.
Yeah, and I think you're right. And that's hard. It's hard as an organization to say, okay, now I see your problem, but these are the rules. And if you decide to bend the rules, fine, just understand that's a risk when you bend the rules, right?
And kind of go back to saying, like, an example is like someone maybe just needs one more week. Is that considered reasonable or not? That's where the whole ADA comes in. Versus someone, well, I really need 4 more months.
Right.
So like, if you do it for one person 1 week versus 4 months, you may have a business case of one being reasonable or not. So that's where you kind of, am I correct in what
Yeah,
you're saying?
absolutely.
That you know, you have to look at what's considered reasonable. And there's resources out there. I don't know if you're gonna talk about Ask Jan.
Oh, no, I wasn't going to talk about SJM, but feel free to share that.
That's a really great tool when you get to the ADA part to find out for reasonable accommodation. It's a really great tool online. It's called Ask Jan.
Jan, J-A-N?
Yes. It stands for something job and accommodations. I forgot the acronym, but it's called Ask Jan.
Yeah. And I think,
Still, attorneys are good too. I'm not trying to say, oh.
No.
But
I think it's important. That sounds like a great resource, and I think it's a good thing to share. I think that the key to know is to understand is what you think is reasonable and what a court of law might think is reasonable may differ.
yeah.
The truth of the matter is, if your employee asks for a Cadillac accommodation, you don't have to give them a Cadillac. They could get a Ford if it works. The employee says, I'm trying to think of a good one. They have an anxiety disorder. They live an hour away. They drive in traffic every day. It drives them crazy. I don't want to come in during rush hour. Actually, I've had this before. I would like to come in either super early or after rush hour so that I don't have the anxiety of being in traffic. Do you have to accommodate that? Well, it depends on the person's job. One, does their job require them to be there at a certain time, on the phone, on the floor, doing something? Or do they have a job that's a little bit more flexible that could allow them to either start at an earlier time or a later time? Are you even open? Are you open at 7 in the morning? Does the employee's job require them to work with other people? Would it make sense for them then to come in 2 hours before everybody else because they can't actually work with the other people that they need to work with? That wouldn't really be reasonable. But if they have a job where they're pretty insular and they're just kind of pounding out their work and they don't really have to be on the phone or interact with clients or customers or anything at a certain time, it's possible that starting early or starting late could be a combination. You could also say, well, is there a train? Is there let's explore other ways that you can get to work. But yes, that would be the conversation that you're having with that employee. Yes.
I take it this is, they were hired under different conditions and the anxiety is a new.
I mean, usually when we apply for jobs, we put our best foot forward. We don't tell people about things like, oh, I have this anxiety
But
condition.
you knew the hours when you took the job.
Yes. I would argue, yes, I understand exactly what you're saying, but I'm sure that you've got an employee that has asked you for something and you're like, well, you understood this was the job, why are you asking me for that? Happens all the time.
Something probably to use in my personal life.
Perhaps. And then that's the fun part, right? Maybe they got a divorce, so the person who was taking the kid to work school now doesn't take the kid to school, and now they have to do that too. So maybe it's anxiety, but maybe it's also personal anxiety. I don't know. Those are all the fun parts, right? Trying to navigate all of that. But what I'm saying is, the law is going to say, okay, well, can you accommodate this person? And if the answer is, they don't really have to be there at 8. They can get their job done. It's not going to interfere with work. If they come in earlier or later, then that will be considered a reasonable accommodation. Yes.
You said the law requires accommodation. That's only if it's under ADA, right?
Well, yeah. So the ADA, there's also the Illinois Human Rights Act, which also protects against disability discrimination, which is very similar to the ADA.
So would a condition like traffic induce
They have anxiety.
whatever,
So I will tell you what.
Is that
I will tell you what I tell, like there was a time prior to the amendments where we could probably go back and forth on whether or not that really does qualify as a disability. I really do tell employers now, let's just assume it's a disability, because you're going to probably lose at fighting whether or not it is. The law has just made it such that, or the umbrella has gotten bigger, or whatever you want to call, that pretty much everything is considered a disability these days. So, while, you and I could argue that it isn't, and there may have been a time where we would have been able to successfully argue that. I would have been successfully to defend your company under that. When the law changed a few years back, it pretty much made everything a disability. So now we're not even fighting at whether or not it's a disability, it's whether or not we can reasonably accommodate your disability.
I'm just curious, the risk you have if you suspect a disability and the person hasn't disclosed it and has not asked for an accommodation, you said, is there anything that you can do to help?
Right. That's always a tough one. And, there are a couple ways. You could either, the over-helpful co-worker who comes to you and says, Kathy really doesn't want you to know, but she's been struggling with this, right? Or the manager that says, I don't know what's going on with Kathy. She's just all over, she's not focused, she can't pay attention, I think something might be wrong with her. But the employee hasn't done anything. Well, as an employer, once you have reason to know or to suspect, you have an obligation. Because what the employee would say, and again, I know I apologize, I'm a cynical defense attorney. This is what they do when they file lawsuits. They say, well, they saw me every day. They knew I looked horrible, I wasn't myself. They knew something was wrong. Or, best friend, she told you something was wrong and you didn't do anything. So, yes, employee privacy issues, all of that is, you want to keep it very kind of light in general. We've noticed that you haven't been doing whatever like you normally do. Is everything okay? Is there any way that we can help? Give the employee, don't say, we think you have a disability, right? But whatever it is, and allow the employee to give them the opportunity to share what's going on. Obviously, you can't accommodate a disability that you don't know. And you've done your due diligence by then asking and going to that employee. But if you don't, then the defense will be, well, they knew. Of course they knew.
Document that conversation.
And obviously document the conversation. Yes, sir.
Just to make sure I've got it straight. We can't ask about the disability when we're hiring someone.
No.
So
No.
if you show up on the first day and say, oh, by the way.
No, you can't, unless they bring it up.
Right, maybe we find out, but you can't ask them, will you require any accommodations for disability?
No.
That's off limits.
If they bring it up, then you can ask.
Right.
How do you propose that you'll be able to do
But
this job?
otherwise, so they show up on day one and say, oh, by the way, I can't go up that one step.
Or if it's an obvious disability, like for instance, the person is blind, all right? You set up the interview, you didn't know, the person came in, they've got the stick and the glasses. It's pretty obvious that they have some sight impairment. At that point, it would be if the job required visual, your sight normally, you'd ask, how do you think you can do this job? Now again, we're not. I'm just going to throw this stuff out just because anytime I get a chance in front of people I want to talk to, I like to share this information. When you're interviewing folks, you want to ask everyone the same questions. So one of the examples I like to give is an employee shows up for an interview. They're 6 months pregnant. It's pretty obvious, all right? They say absolutely nothing. What do you say?
Absolutely nothing.
Absolutely nothing. How do you figure out whether or not the employee is planning on taking leave or how they're going to be able to handle it? What can you ask?
Well, if you ask all your people, do you anticipate that you need vacation time or something off this year? But I wouldn't even ask that question about other
Is there any reason that you think that you would not be able to, do the job or be here or whatever?
Ask that to everybody.
Then you need to ask everybody that question. So again, I'm sorry, yes.
Doesn't your job description cover you in a lot of cases as our job requirements. I'm seeing it more and more where it's, job requires sitting for so long, standing for so long, walking, talking, all that kind of thing. Or do you have to also prove that they ever saw it?
Well, that's something you could go through in the interview. This job requires these things. Is there any reason that you believe that you would have problems with these things? And you would ask that to every applicant. You could ask that for, the strapping young 25-year-old who comes in and looks healthy as a horse, and you ask it for someone who may be a little bit older, who you might have a question about. But if you have to ask all of the applicants, yes. Did you have a question, sir? I'm sorry.
You've already covered it.
Okay. Great. This is great. Great questions. All right. Anyone in here feel that they have been subject to leave abuse in the past? You've had an employee who kind of was fast and free with the leave or started. Yeah. All right. So some of the patterns are repeated Monday, Friday absences, right? Oh, I'm not feeling well today. I can't come in on a Friday. Basically giving themselves a 4-day weekend, all right? That may be one thing. If it's a job that requires overtime and you've got kind of a fair system of distributing that overtime, always refusing to work overtime or on the weekends. Maybe they have a second job and that may be interfering with your job. So, if you've got somebody out on leave or, there's some disability or some concerns, if you have a documented pattern that would lead you to believe that there's some type of a leave abuse going on, you may be allowed to go to communicate with that person's doctor and say, okay, does this person really need to be gone every Monday and Friday? Is there anything about their condition that requires them not to be here on Mondays and Fridays? That would be legitimate. It would need to be documented. It would need to be something that you are observing over and over again. But yes, it does happen. Yes, sir.
If you've got an attendance policy in effect, and it's across the board, consistent for everyone, you're missing overtime, it's mandatory. That could be a violation, which is, for us it is. Monday, Friday, absences, undocumented. You're not bringing in doctor's statements to say why, unexcused absences. You start to do this.
Absolutely. You would use your attendance policy and enforce it. Often what happens is, so then you go to enforce your attendance policy and then they say, oh, well, the reason why is because blah, 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 blah. And the doctor said this, and oh yeah, I'll get a note. And then they go get a note and they get certified, which is retroactive. So I'm with you. Stay on your attendance policy, enforce your attendance policy. But what does happen probably every other time is something like that.
That's like with paramedic. If someone has a condition, or they might need to be off a couple times a month, and that's where the pattern starts. So,
It's usually where you see it.
if they have a certification and the doctor says that they need to be off a couple times a month, then you can't really discipline them.
Or,
Because, then you go to the pattern, but you can't really, is that what you're asking?
yeah, no, I got a call.
Say that's what you do.
Yeah.
If you have a policy, you follow it.
But if they're approved for intermittent.
They should be bringing it to you to begin.
Right, but they would be certified, so what happens if people have.
What's the certification? What's the reasons?
Right, so.
Can you accommodate that based on the fact that?
So when an employee says that they have to take a leave based on either their own health condition or the health condition of like a close family member, they'd have to fill out a form, right, that says this is the case, and it'd have to be signed by a doctor, and then, yeah, I'm sorry.
I think you're confusing FMLA with ADA. And I'm saying is that if an employee is qualified for FMLA, intermittent leave, you cannot discipline for those absences.
Exactly right, but they have to bring that in. They
Right.
Go through the leave policy before the
Right,
pattern.
that's what I said, they were approved.
Right,
Those
but
persons
again, the
said.
issue is that first you have to discipline if they're not bringing it to you up front. If they're not coming to you saying.
Yeah, we're
"I
saying the
need
same
this
thing
time
just
off."
differently, as my
Right.
first thing is if they have been, if you have approved them
Exactly.
for a thing, you
Then you
can't.
follow that process.
Yeah, I think you're, yeah.
That's
We're saying,
secondary.
I think you are.
Same thing here.
Yeah, and this is what we're talking about right now. So if there's a question, get them recertified. You know, if you have a question about it, if you know, well, this, I got a call a month ago. Employee, I can't remember what her condition was, but she had to take medication. The medication made her really sleepy in the morning. So her certification was that, well, she might not be able to start at work, at 8, so, maybe she'll come in later. Well, what was happening was she was coming in at like noon or 1 o'clock every day, and it became a problem, and so I said, well, recertify. I mean, that doesn't make sense. Can they change? You don't ask, as the employer, can you change your dosage, but this is prohibiting her ability to come to work. Is there something that you guys can do about this? Have them recertified, or, as you were just saying, you treat it as a non-FMLA absence, subject to your policy and that discipline if the certification isn't timely or proper. It's their duty at that point, if they're not doing your part, and you've given them the information and you've given them the forms to fill out, and they're not doing their part, then you go ahead and you treat them as such under your attendance policy. But the big thing to take away here, and this is the frightening thing, there really is no safe zone outside of the FMLA. And the EEOC right now has been really kind of tough on this. They're basically enforcing this. You may have leave obligations to your employees, regardless of whether or not they're covered by the FMLA, which is why that might be where you start, but that's not where you finish. And it can be frustrating as an employer, so we get that. Am I doing on time? I just want to.
It is 5 minutes after 10. So
Okay. Oh, great. Okay. All right. So, common pitfalls in this area. I think actually you touched on this earlier. Waiting for magic words. Sometimes your employee's not going to come to you and say, I believe I have a disability that needs to be accommodated. So, you've got to be observant. Your managers, if your managers are coming to you and saying this is a problem, the nosy coworker who comes and, avails themselves and tells you what they think is going on with this person, that's notice. You got to act on it. I'm trying to remember why I included this only with the full release. Meaning that if you can only come back to work with a full release. Well, is that true? Probably not. The person probably can come back with some restrictions as long as they're able to do the essential duties of their job with or without accommodation. So that's our policy. We're sticking to it. It may be your policy, but they might be entitled to more under the law. Usually what I find is that employers' policies are more generous than the law, right? These are your employees, you want to treat them well, but let's not just stick to our policy. Make sure you ask Jan, or you ask your HR person, or you ask your in-house counsel, or you ask somebody like me before you kind of make a snap decision. Also, you can't do this job. Maybe you're assuming that the person isn't able to do the job because you haven't really explored the job duties and requirements and what the person is and isn't able to do. That's what the law calls the interactive process. It can be a little complicated, but we have to do that before we just say, okay, this person doesn't have a right hand, they can't do the job. They might be able to do the job. Let's look at the job. Let's look at what's involved in the job, the tasks of the job, and see if the person can do it with reasonable accommodation. We're not terminating you. We're filling your job. Okay. You might not be terminating them, and you might need to fill the job, right? That's something you definitely wouldn't want to say. The key here is that both the ADA and the FMLA require that that person be restored to a similar or their position. The ADA, if their restrictions or whatever can be accommodated. So this is something I wouldn't say. Prescription drug issues. What if you? I get calls about employers who think their employees have alcohol abuse issues or prescription drug issues. Maybe the prescription drug issues have to do with the medication that they're taking for their disability. Those are kind of sensitive topics, which is why these conversations really need to be on a need-to-know basis. You really want to take them out of the manager's hands if at all possible, and keep it with someone from HR and that individual, because you don't want to start getting into, well, my manager said I shouldn't be taking this drug, or what have you. So these conversations should be on a need-to-know basis. But that can be a tricky issue, because maybe the drug they're taking is something to manage their disability. And if that's the case, then we need to understand, well, what's happening, and is there a way that we can work around this? The biggest mistake that I see is not talking to your employee. Sometimes it's a problem employee. They're gone on a leave. You're good riddance. I don't have to deal with that person. And then it's time for them to come back, and you're dreading it, and then you don't hear anything, and you're like, oh, maybe we can fire them. And it's not a critique. I just understand how this works. You need to be in communication with your employees to know what their plans are, what their intentions are, so that you can actually accommodate them. But just letting someone sit and having no idea when they're coming back. Maternity leaves are easier. There's usually kind of, you know when someone's going to come back from that. But some of these other issues can be tricky. And then confidentiality issues. There's all kinds of employee privacy things, concerns dealing with health and medical information. So again, it really needs to be on a need-to-know basis. These files need to be kept separate from personnel files. It doesn't need to be in their personnel file. Now, obviously if the things that would fall under your absence policy or your absenteeism policy would go into personnel file, but FMLA, health stuff, you want to keep it separate. So just a few tips. Because we know that these laws interact and overflow, you want to update your policies so that they include flexible cross-referencing language. As I just said, communicate with your employees before, during, and after their leave. Be consistent about when you're asking for your medical documentation. Anyone who's going on a leave, you're asked for it. Even if you know they're having a baby, you ask for it. This is a hard, this can be a hard one, figuring out how to accommodate a worker. It shouldn't just rest with one person. That's a hard decision. It shouldn't be made in a vacuum. You want to try to think about a centralized decision process. Whoever those people are going to be in your organization to kind of help you think through what a reasonable accommodation is. And really importantly, make sure that your first line supervisors and managers know about the policies. They might not need to know all the details about this individual, but they need to know that you have an FMLA policy, and that a person can take job protected leave for their own serious health condition or the serious health condition of a family member, because their knowledge is imputed to you. So if your employee goes to the manager and says, yeah, my wife has just been struggling, she got a recent cancer diagnosis, she's doing whatever, he should be able to say, oh, do you think you need to take some FMLA? He can only do that if he knows about the policy. So it's really important, and that's, again, something that I like to do a lot, but I do a lot of manager training around these issues. So leave also can be considered a reasonable accommodation under the ADA. But remember, there are other things that can be reasonable too. So a modified schedule, we've talked about that. Is there some type of ergonomic adjustment or equipment or device or a workaround that you can use that isn't exorbitantly, overpriced, that would be allow that individual to do their job? Or are you able to temporarily modify their job duties? I like to say this, and I think I said it already, extended leave may be a reasonable accommodation, but eternal leave is not. So at the end of the FMLA leave, you're going to want to look and see, is there a disability issue? Do we need to extend this leave? But that doesn't mean that the employee gets to be out for another 3, 4, 5, 6 months. And going back to this gentleman's point, termination may be an option when the employees do not participate in the process or have no reasonable likelihood of return to work. So the employee isn't communicating with you, they're not telling you what's going on with them, they're not getting the certifications, they're not doing any of that stuff, then termination is an option. But you want to make sure that you're doing what's required on your end so that you feel covered when you do make that decision, if you do make the decision to terminate. Yes, sir.
Got one that's, that comes up periodically and kind of gnarly, get your thoughts on it. Let's say we have an employee that comes and says, there's some complications in my immigration status that I would like to resolve. And that's going to require me to leave the country for a little while and get some things straightened out. And so it's not FMLA or anything, it's now just a leave of absence that they're requesting, or maybe even saying, okay, you have to resign, but when you come back, we are inclined to rehire you again.
Mm-hmm.
And what precedent do you have to worry about setting in allowing somebody to do that?
So, 2 things. If you have a personal leave of absence policy that person would qualify for, regardless of what the reason is, and the reasons would be outlined in your policy, maybe they fall under that and you don't have to worry about it. If you don't, I would treat everyone the same. If you can't be here for work, then we're going to have to terminate you. You are welcome to come back and apply. I cannot guarantee that you will be hired. Now, in your mind, you might think, I'm hiring this guy the minute he comes back. But your policy, your stated policy should be, you are free to reapply and we'll consider it.
And that's pretty much how we do it. But if somebody looked at it and said, you have to, how come these guys always get these guys got rehired?
Right. So we've seen a lot of what you're talking about lately.
We encourage them to, encouraging them to come back and
Right.
apply,
And-
as opposed to not encouraging them.
I don't want to talk too much out of school because I'm not really an immigration attorney, but I will say that we've seen a lot of what you're talking about in the last few years, especially with the president's executive action, allowing folks who have children who were born here to apply for naturalization. So what happened is you may have hired some people, they had some suspect paperwork that you weren't aware of, and now they're like, oh, I can get right, although there's a question about that because those cases are pending, and that, as I understand, are going up to the Supreme Court now. Oh, I can get right, I can have the proper documentation now, so they come to you because they're good people and they want to say, look, I've got the right stuff now. And you're like, oh, that means you didn't have the right stuff before. So it's a very common practice. It happens a lot. It's been happening a lot the last few years from what I understand. So, but like I said, if you don't have a personal leave policy, I would say you're terminated, please apply when you come back, and if we're able to hire you, we will. Yes, sir.
Just curious, I have 2 different employees. One would be considered the other a manager, the other one's a consultant. Their wives are pregnant. What's my obligation for my employees as a workaround when they're...
So do you have a paternity leave policy?
I don't know. I mean, I have a human resource manual put together by human resource
Okay.
consultant. I have to look at it and check.
So the industry standard has been, to the extent that you have a paternity policy, what I've been seeing is that it's usually somewhere about 2 weeks. Arguably, you could make a case for FMLA. You could say that the husband is taking time to take care of their wife or their newborn child, and they could do it under their serious health condition. Now, the kid doesn't have a serious health condition, so if you're being technical, maybe their wife had a C-section, had some type of surgery, isn't able to walk or do things, so therefore the husband would need to be home to take care of her and the baby. That would qualify under FMLA. If you didn't have your own paternity policy. So you might want to check to see if you have one. If not, have the employees indicated what they intend to do or want to do? Have they indicated that they want to take time off?
Well, I
or
have a second cousin who works for me, and his wife kind of is pregnant. She brought, what's your pregnancy policy? And I said, well, it's usually whatever Andy wants to do.
Yeah.
He's my second in command, and I'm a pretty reasonable employer when folks have stuff that come up.
So the only thing my only warning to you is just to be consistent. So if you're,
Consistent.
yeah, if your second cousin says, hey, I want to take some time off, as my wife just had a baby, and it's not really an FMLA certified leave, you want to make sure that you're doing that for other folks who indicate the same.
What I usually do is I say, the due date, you have a week either side of that, you're grounded, you're not traveling or flying, and you work from home, you got your laptop, keep up with stuff, I trust you to do your job, and but
Yeah.
after that window, you're back on.
And if that's your practice, then that's fine. And if you're consistent with your practice, that's fine. If you want to document that you can do that as well. Now, mind you, like I said, in the one scenario that I just gave, that an employee could apply for FMLA leave, right? If there were complications or there are complications with the child, when a child was born, that might be an FMLA qualifying event for the husband. So those are things to consider as well. How are we doing on time?
10:20.
Okay.
I have a question.
Mhm.
Same question. So, can it be unpaid?
Yes.
Okay.
Uh-huh. It doesn't have to be.
Can they take vacation time instead of?
They can take vacation time. Your leave can just be unpaid leave.
For like a week?
Right, and if you choose to take your vacation, you take it. Yeah. All right, I'm going to just kind of float by this. I know we've been asking questions throughout, so I don't feel like we need to have a designated question and answer period. But I think I heard someone say all of the above earlier. Was that you, John?
Yes.
And I think you're right. Employee calls in. Yeah, it could be FMLA. It could be a medical and disability leave. It could be any of these things, which just proves how kind of complicated all of these issues are. And kind of all the things you need to kind of check through when you're going through these issues. Well, it may not be this, but maybe it's ADA. Maybe it's leave as a reasonable accommodation for a pregnancy-related condition. So I thought I had a slide in here on this, apparently I don't. But last year, Illinois passed a pregnancy law which protects applicants and employees who are pregnant or have child-related health conditions. And so under that, it's pretty clear that leave can be a reasonable accommodation for an individual if they have a pregnancy-related condition. And that could run concurrent with your FMLA, but just another thing to think about. All right, we'll go through this pretty quickly. I'm willing to entertain questions, and it's probably the better kind of place for this. We can kind of review it. But independent contractor versus employee status. Well, this is always a fun one. I know why employers want to make everyone a contractor. It's cheaper. You don't have to pay benefits, you don't have to pay taxes. But we really want to be careful when we're looking at these status issues that we're taking the steps to make sure that the folks that we believe or want to be contractors are truly treated as contractors. So, factors to consider. The primary factor, every test across the country, no matter what jurisdiction you're in, is the extent of control by the employer. Does the employer control the manner, means, and methods of this individual doing their work? Does the employer provide all of the supplies and tell you when to do it and how to do it? Those are the things, that's the major factor, but there's lots of other ones. Do you have the right to discharge, or is it a contract? Has a definite end and beginning? How are you paying them? If you're paying them like an employee every 2 weeks, it's going to start looking like they're an employee. Is it a project? You pay it like you pay a project upon completion or certain benchmarks during the course of the project. Who's supplying the tools or equipment? Are you or the contractor? And I say this to say that these are the tests that we look at. It doesn't mean that if you've got some of these that your person's not a contractor, but if you've got all of these, chances are they're not. All right. What do the parties themselves think? Does your contractor think they're an employee? I mean, it's just, you know, that's what, and have they taken steps to act like they're an employee of your company? Oh, sorry, that's covering up. Control over the means used and the results of achieving the contract. And that's kind of what I was talking about before, the extent of control by employer. All right, so last year, the Department of Labor issued an interpretive bulletin. And what the bulletin basically said was, look, we're going to start at the default that all these people are employees, and you're going to have to show us that they're not. So how much of what they're doing is an integral part of your business? If it is, that starts to look more like an employee relationship. Does that worker's skills affect his or her opportunities for profit or loss? If it does, that person's looking more like an employee. These are some of the other things that we talked about: the equipment, the facilities, the permanency of the relationship, the nature of and degree of control by the employer. So, what do? You have to, before I do that, you have to have a contract. The contract needs to be clear. You need to say specifically, this person is an independent contractor. They're not an employee. You know, we're going to 1099 you. All of these things need to be very clear. And then you don't want to start also throw words in like, you know, we will fire you, we will terminate you. No, you will terminate the contract, right? I see this a lot when I get these sample agreements. What are some steps to make sure that you're classifying your workers as employees? These are going to be all the fun things, right? So if these are people, you want to make sure they're employees, then you're withholding and paying federal and state income taxes. You're paying Social Security and Medicare contributions. You're creating unemployment accounts and paying taxes. You're providing and paying for workers' comp insurance. And you're providing worker-employee benefits. All right, I have seen organizations or companies who have had what they deem to be independent contractors, but they provide them with employee benefits. That's a hallmark of an employer-employee relationship, okay? But if you want to make sure that someone's an employee, you're doing these things. I want to say, yeah, the big takeaway from all of this is you want to clarify what the relationship is with your independent contractors. And if you need to kind of step back with some to make it less like an employer-employee relationship, you should do that. Or if you want to embrace them and pull them into the fold, you should do that as well. Make it official. But kind of just letting things go is not going to help you, because what will happen eventually is they're going to get hurt and then they're going to file a workers' comp claim, right? Or something's going to happen and they're going to say, well, yeah, I mean, I was basically an employee. They told me when to come and go and what to do and how to do it. And that's what you want to avoid.
We see a lot of that in Central Illinois with non-union contractors that are hiring individuals as independent contractors, whether it's a roofing, electrical job, short term, and it's created a lot of issues, especially in workers' comp and also with OSHA with liability. So
yeah,
it's interesting.
It is. It is. I think it's, you know, when the economy kind of tanked back in 2008, and we saw a lot of people get laid off and fired. When employees started coming back into the workforce, they were coming back in these what we call contingent roles. So coming back as temporaries or part-time or contractors. And so I think we've seen a lot more of these issues recently just because everyone didn't come back and get a full-time job. And so there are a lot of these kind of when I say questionable, I don't mean that they're not legitimate, but just not traditional relationships now that we have with our employees. Yes.
So, go back to your pool example. You hire somebody to put in the pool, one of the things you're going to do is ask for a certificate of insurance. So now you're bringing somebody to do IT work for your company. You ask them for a certificate of insurance. Does that create a prima facie, indication that there's an independent contractor relationship?
I think it would help. It'd be a factor that would contribute to saying that it is, yeah. I think so. Any other questions or comments on this topic? Well, I want to thank you all so much. I thought I was done. Guess I wasn't. Things to include in your agreement. You want to specify what the individual is hired to do, all right? You just don't want to say, we're bringing you on to work. What's the scope of work? And it needs to be clear. What is that contractor, that individual, what are they going to be responsible for? What tools, what costs, what things are they, and what are you going to be responsible for? That should be laid out in the contract. How are you going to pay them? If it makes sense to pay them every 2 weeks, fine. I don't like that, but if that's what you're going to do, that's fine. Put it in the contract, but you're putting it in the contract and you're saying, but this is, it's 1099, we're not withholding, you're a contractor. And then think about the length of the relationship. It should have it should have an end. And if it doesn't, then are you really hiring a contractor or are you hiring an employee? Do they have to do the work on your premises? Or is it work that can be done away from you and then brought to you when it's finished? That should be included in the contract. And how is the relationship going to end? Is it done on the completion of work? Will we reevaluate and see if there's more work that we want for you to do? That's also something that you would want to consider to put into the contract. So I want to thank you all for your patience this morning. Again, my apologies on being late. If you have any questions, feel free. Here's my info. Are we going to be sharing this with them?
Yeah, if you allow us to, yes.
Yeah,
Absolutely.
yeah. We'll send it to you by email. But please feel free to give me a call if anything comes up. And it was really nice to speak with you all this morning. Thank you.